Welcome back to the deep dive. So today we are tackling a subject that I think a lot of people assume is maybe a bit out of their
A
league.
bit intimidating, yeah.
Yeah,
Reserved for the super wealthy.
exactly. We're talking about navigating the world of trusts in South Africa. We've gathered some really great source material that tells a much more practical story.
That's absolutely right. The core of our insights today comes from a fantastic source, The Beginner's Guide to Trusts in South Africa, by trust consultant Lumke Sturman.
And what this guide really hammers home is that we need to sort of change how we think about trusts.
Right.
They're not these abstract, scary legal things. They're powerful, protective tools that are available to, ordinary citizens.
Our mission today is pretty clear then. We want to give you, our listener, a real shortcut to understanding the huge benefits here. We want to move trusts out of that elite corner and show them for what they are.
Which is critical planning infrastructure.
Yes. And look, we have to acknowledge that the legal framework in South Africa is complex. It
Yeah.
is. It demands a really careful, informed approach. But the potential upside, it's just so significant that the time spent learning about it is completely justified.
So let's start at the very beginning. Let's say I have a will. It's comprehensive. It details who gets what. Why on earth would I complicate my life by adding a trust? What does it actually add?
That is the perfect question. It goes right to the heart of it. The simplest way to think about a trust and how the source material frames it is as a protective container for your wealth.
A protective container. I like that.
It's a legal arrangement.
Yeah.
And what happens is the ownership of your assets, your house, your investments, is formally transferred out of your personal name and into the name of the trust. Then you appoint trustees to manage those assets, but strictly for the benefit of the people you name, the beneficiaries.
Okay, wait. So if I transfer my assets, I don't legally own them anymore. Isn't that a huge psychological hurdle? Giving up ownership to what, a board of trustees?
It is the biggest hurdle. But, that's the price of protection. You're trading personal ownership for structural control.
Okay, explain that. Structural control.
You, as the founder, you set all the rules. The principles, the limits of the trustee's power, it all goes into a document called the trust deed. You could even be one of the trustees, guiding the decisions. But the key distinction is this. Because you don't own the assets anymore, your personal creditors or any future legal claims, they can't touch them.
Wow. Okay, so that's the first major benefit then, asset protection. That alone feels like a game changer.
It is. For anyone in a profession with potential liability, doctors, engineers, company directors, this kind of shielding is almost non-negotiable.
So if you're sued personally,
The family home or the investment property that's sitting in the trust is typically safe, as long as the trust was set up correctly, of course.
okay, so protection is number one. Let's pivot to what everyone really cares about. Paying less tax, legally.
That brings us to benefit number 2, tax efficiency. A trust lets you do some pretty sophisticated tax planning. So instead of all the income from your investments being taxed in your hands at your high personal rate,
Hmm.
the trust can distribute that income to different beneficiaries. And if those beneficiaries, say your child who's a student or another family member with a low income, are in a lower tax bracket,
Then the overall family tax bill goes down.
exactly, potentially by a lot.
That's a huge annual saving. Okay, so what's advantage number three?
The third is all about estate planning. This is about avoiding what can be a bureaucratic nightmare after someone passes away.
The probate process.
Yes. When assets are in a trust, they don't form part of your deceased estate, so they completely bypass the master of the high court.
Which means no 6 to 24 month delay.
No delay, no executor's fees on those assets, and none of it becomes public record. It's just a smooth, continuous handover, not a legal freeze.
And that smooth handover seems to connect to the last two benefits, which are continuity and privacy.
They're completely linked. The fourth benefit is continuity and control. Your financial legacy just keeps going seamlessly. It's managed by the trustees you chose, following the rules you wrote. And fifth, as you said, is privacy.
Right.
Because it's not in the public deceased estate process, your wealth stays confidential. And that's a big deal for a lot of families.
Okay, let's move beyond those immediate wins and talk about the long-term power. Building something that lasts for generations. The sources mention something fascinating about South African law, this idea of perpetuity. How does that help a trust protect assets from, say, bad decisions made by future generations?
This is where, SA trusts really stand apart globally. In many countries, there are rules that limit how long a trust can exist. But in South Africa, a trust can exist in perpetuity.
In perpetuity, so forever.
Potentially, yes. There's no rule against it. The trust you create today could, legally, still be benefiting your great-great-grandchildren. You're future-proofing the wealth.
The idea of perpetuity is almost philosophical. I mean, we plan for 10, maybe 20 years. But a structure that could last for centuries, that's a massive shift in how you have to think.
It forces the trustees to think differently. Their decisions have to be prudent, focused on preservation, not just short-term gains. And this directly answers your question about, poor decisions by heirs. If you leave your child 10 million rand in a will, they own it. They can spend it on fast cars. They can lose it in a bad business venture. It's theirs to lose.
But if it's inside the trust...
Inside the trust, the actual capital is protected. The child is a beneficiary. They might get income from the assets or catch distributions if the trustees decide it's wise. But they can't touch the underlying assets themselves, the property, the business shares, because the trust owns them.
So the trust is basically a firewall against financial immaturity or beneficiaries' divorce or their own business failing.
Precisely. It's like building professional wealth management right into your family's DNA. And it's flexible. If the trust deed is drafted properly, it can be amended to adapt to new laws or family situations over the decades.
Let's pivot to some specialized uses, because trusts aren't just for general family wealth, right? They can solve some very specific, very sensitive problems.
Absolutely. One of the most powerful and, frankly, important uses is something called a special trust, specifically a Type A.
Okay, what's that for?
This trust is recognized under the Income Tax Act, and it has to exist solely for the benefit of a person with a severe physical or mental disability.
And the benefit here is, I'm guessing, financial, beyond just providing structured care.
It's massive financial relief. It's all about the tax treatment. Normally, a South African trust is taxed at a flat rate of 45%.
Ooh, that's high.
It's very high. But a Type A special trust, it's taxed at individual rates.
Wow. So it gets the same rebates and thresholds as any individual taxpayer.
Exactly. And you can imagine what a huge difference that makes. It means the income that's there to support a vulnerable person isn't being cut in half by tax. It ensures the maximum possible resources are available for their long-term care.
That's incredible. Okay, now let's look at a different scenario. The entrepreneur, the business owner, who built something from scratch. Succession is always messy. How do trusts help there?
That's where business trusts come in. Or, more accurately, a trust that holds the shares of a family business. The number one benefit is seamless continuity. If the founder dies, the business just keeps running. The shares are held by the trust. The surviving trustees are in charge. There's no 3-month halt while the estate gets wound up.
And I imagine there's a big estate duty advantage here, too, if you transfer the shares early.
That is the core strategic move. You transfer the shares into the trust early on. That means all the future growth in the business's value happens outside of your personal estate.
So you avoid massive estate duty down the line.
You do. And it also stops the ownership from being fragmented. Instead of 5 kids each getting 20% of the shares and arguing over the company's direction, the trust owns 100%. It keeps control unified and just distributes the profits fairly.
Okay, so we've established the benefits are immense, but realizing them means navigating a minefield of regulations. Let's talk about the practical reality. The complexity, that means you really need expert guidance.
This is probably the most important takeaway from all the source material. This is not a DIY project. Setting up a trust is so much more than filling in a template. It requires absolute precision. You need a professional to help you define your objectives and choose the right structure. Is it a discretionary trust or a fixed trust? They have completely different implications for control and tax.
And even just getting the assets into the trust isn't simple, is it?
Not at all. That transfer can trigger major tax events. You then strategically decide if it's a donation, which could mean donations tax, or if it's a sale, which could mean capital gains tax.
Get that wrong, and you're starting with a big unnecessary tax bill.
Immediately. And then there's the human element. Choosing your trustees.
Right. These people have control over everything you've built.
It's crucial. The sources all stress that you need a mixed board, maybe a family member, a professional like your accountant, and this is key, a truly independent third party. The courts look at this very, very closely.
So what's the easiest way for a trust to be challenged in court? To be declared a sham?
It's that independence test, hands down. If the founder continues to treat the trust assets like their own personal piggy bank,
using the trust's property as collateral for a personal loan, that kind of thing?
exactly that. Or just not holding proper minuted trustee meetings. If a court sees that, the trust can be declared a sham, and all of that protection, it just vanishes.
And the complexity doesn't stop once it's set up. There's ongoing compliance. I saw something mentioned called the income attribution rules. What are those quickly?
Think of them as SAR's guardrail. They're complex rules that determine if the income in the trust is taxed in the trust or if it gets attributed back and taxed in the founder's hands.
So it stops people from just using it as a tax shelter.
That's the idea. And navigating those rules year after year requires deep tax knowledge and perfect record keeping.
It really sounds like the cost of getting professional help up front is nothing compared to the cost of getting it wrong.
That contrast is the strongest warning in the material. The cost of proper setup is minor compared to the catastrophic cost of a mistake. A misapplication of tax rules can lead to huge bills. And a failure to maintain independence means your asset protection fails right when you need it most.
This has been an incredibly insightful deep dive. I think it's clear that a trust, when it's planned and managed correctly, isn't some niche product for the elite. It's vital family infrastructure. It protects your legacy, shields your assets, and provides real long-term peace of mind.
It is. But it's also clear that achieving those powerful benefits requires specialized knowledge to navigate the intricacies of South African law, especially around asset protection and tax. For listeners who want to match the structure to their specific needs and avoid all the costly mistakes we've talked about, seeking expert consultation is just paramount.
And as we said at the start, these insights into securing your family's future are drawn from the fantastic guide by trust consultant Lumka Sturman. If you want to explore this in more detail, you can visit her website. It's www.lumkasturman.com.
And maybe as a final provocative thought for you to consider, it relates directly to that idea of transferring and appreciating assets early. If the growth of your assets inside a trust escapes future estate duty, then you have to ask yourself, given the power of compound growth over time, what is the true cost of waiting to establish that protective container? Every day you wait is another day that growth is happening inside your taxable personal estate.